Hello बच्चों, let's see passage 1. Passage 1 talks about the Indian Constitution's part 1, Article 1 to 4, lays down the foundational framework for the Union and its territory, defining India as a union of states. जो article जो part 1 है वो इंडिया को define करता है as a union of states. This unique federal structure, as explained by Mr. B.R. Ambedkar, establishes an indestructible union, unlike the American Federation, which was formed by the agreement among the state. तो हमारा जो है वो एक indestructible यूनियन है, बट अमेरिका का जो है वो एक अग्रीमेंट से बना हुआ है, तो वो डिस्ट्रक्ट हो सकता है. इन द इंडियन कॉन्टेक्स्ट, स्टेट डज नॉट पोजेस द राइट टू सेसीड, एम्फसाइजिंग द इंडिविजुअलिटी ऑफ द नेशन. तो मतलब इसमें ये है कि एक जो नेशन है वो अपने आप को सेपरेट नहीं कर सकता है पूरे नेशन से, क्योंकि एक जो हमारा नेशन है वो इंडिविजिबल है, मतलब डिवाइड नहीं हो सकता है. Article 1 distinctly categorizes India as a union of states and not a confederation. This terminology was deliberately chosen to signify the permanence of the union and the inability of state to break away. The phrase Union of India, अब Union of India जो है उसको refer किया जाता है specifically to states within the federal structure sharing power with the central government. However, territory of India, अब दो चीज यूज की जाती है, यूनियन ऑफ इंडिया और टेरिटरी ऑफ इंडिया. तो अब टेरिटरी ऑफ इंडिया को यूज किया जाता है encompasses a broader area including both states and the union territory as well as any other territories that India might acquire. Now let's see Article 2. Article 2 grants Parliament the authority to admit or establish new states in the union. अब अगर न्यू स्टेट्स को बनाना है तो उसके लिए आर्टिकल 2 में पावर दिया हुआ है पार्लियामेंट को. दिस पावर इज नॉट लिमिटेड टू एक्जिस्टिंग टेरिटरीज ऑफ इंडिया, इट एक्सटेंड टू रीजन दैट वर not initially part of the country. A historical instance of this power's application was the incorporation of French settlement. अब जब पौंडीचेरी को इंडिया का पार्ट बनाया गया था तब भी इस आर्टिकल का यूज किया गया था. Article 3 addresses the internal reorganization of states, including the alteration of states boundaries, areas and names. The process of such reorganization involves several steps. अब reorganization हो रहा है तो उसके क्या क्या steps हो सकते हैं. Let's see. Step number 1 says the introduction of the bill in either house of the parliament, but only upon the president's recommendation. Step 2 is if the bill concerns altering state boundaries or name, it must be referred to the respective state legislature for its opinion, though parliament is not bound by its opinion. मतलब opinion लेना जरूरी है, but उस opinion पे आप काम करना चाहते हैं या नहीं, that is a choice that parliament has. Third is in cases concerning union territories, the president is not required to seek opinion of the territories legislature. This article highlights the stark contrast between the Indian Federation and the federations like US or Australia, where states in territorial integrity cannot be altered without their consent. Article 4 complements Article 2 and Article 3 by enabling necessary legislative and administrative adjustment following the formation of new states or the alteration of existing one. It also allows the modification of the first and the fourth schedule of the Indian Constitution, which lists the states and the union territories and their representation in the Rajya Sabha respectively. Significantly, Article 4 clarifies that the law enacted under Article 2 and 3 does not constitute amendments to the Constitution under Article 368 and hence require only a simple majority. तो जो Article 2 और 3 में regulations आ रहे हैं वो सिर्फ simple majority उसके लिए needed है. In summary, these initial articles of the Indian Constitution establish a robust and centralized federal structure where the Union holds significant power over the composition and boundaries of the state. This structure ensures the unity and integrity of the nation while allowing for flexibility in territorial adjustments to accommodate political, administrative, or socio-economic changes. The distinction between Union of India and Territory of India is crucial in understanding the federal dynamics and the central government's overarching authority in matters of state reorganization and territorial integration. तो हमने जो पढ़ा कि यूनियन ऑफ इंडिया और टेरिटरी ऑफ इंडिया कब रेफर किया जाता है, वो एक बहुत ही इम्पॉर्टेंट और क्रूशियल डिस्टिंक्शन है जो हमें हेल्प करेगा इन knowing the power of the central government. Now let's see the questions. Question number 1 says, how does Article 1 of the Indian Constitution conceptualize the idea of union of states in contrast to the federation formed by an agreement such as the USA. Let's see the options. Option number A says it allows state to retain sovereign authority. Option number A is a wrong option because in our country states do not retain sovereign authority, which is contrary to the other federal structure, and hence this is a wrong option. B says it implies a loose confederation of the states. This is again a wrong option because we have already studied in the passage that it is not a loose confederation. Instead, it is a union of the states. C says it signifies a union formed by the alter aggregation of states. Option number C is also a wrong option because it signifies an consensual aggregation, but that is not the case with the Indian Union. D denotes a union where the states have no right to secede. This is absolutely right option. We have already read in the passage that the states in under the Indian Constitution do not hold any right to secede, but are bound by the integration of the Indian Constitution. Let's see question number 2. It says under Article 2, the power of Indian Parliament to admit or establish new states differs from the power under Article 3 in which of the following ways. हमें बताना है कि कैसे आर्टिकल 2 is different from article 3. Let's see options. A says article 2 allows alteration of existing state, whereas article 3 permits admission of new state. Option A is a wrong option because article 2 do not allow the alteration. That is a power that is granted under article 3. B says article 2 pertains only to territories outside India, while article 3 deals with territories within India. This is also a wrong option because these are the powers which are not limited to territories but are given to the parliament, and hence this is a wrong option. C says article 2 deals with admission and establishment of new states, whereas article 3 pertains to reorganization of existing states. This is a absolutely right option because when we see article 3 has established a procedure or a step by step guideline for seeking the opinions in case of reorganization. Article 2 deals with the admission. D says article 2 requires consent of existing state, unlike article 3. That is again a wrong option. Let's see question number 3. It says the referral of a bill to the state legislature under article 3 when altering state boundaries or names serves what purpose in the Indian legislative process. Let's see options. Option number A says it is mandatory step for the president to pass the bill. Option number A is a wrong option because it is not necessary or mandatory for passing of the bill. B says it provides a mechanism for state to veto changes in the boundaries or the name of or the name. This is again a wrong option. It is not a veto change. C says it is a procedural formality with no binding effect on parliament's decision. This is absolutely right option because when the bill is being referred to the state legislature, it is for merely seeking an opinion from them, and this opinion is also not binding on the parliament. If parliament wants to follow this opinion, they can follow. If they don't want to follow this opinion, they can very well not follow this opinion, and hence this is merely procedural formality with no binding impact. D says it allows state legislature to propose amendments to the bill. Again a wrong option. They can propose, but whether this opinion will be accepted or not is totally on the parliament. Let's see fourth question. Fourth question says article 4 of the Indian Constitution in relation to article 2 and 3 signifies which of the following about constitutional amendments in India. Let's see option number A. It says laws under Article 2 and Article 3 are considered constitutional amendments and require a special majority. Option number A is absolutely wrong option because Article 2 और 3 के अंडर जो भी laws पास होते हैं उनको हम constitutional amendments नहीं मानते हैं और वो simple majority के through हो सकते हैं totally. B says Article 2 and 3 laws are considered constitutional amendment but do not require any special majority. Again a wrong option. Although the latter part of the option is correct that they do not require a special majority, but the former says that it is a constitutional amendment, which is a wrong statement. They are not a constitutional amendment. C says laws under 2 and 3 are not considered constitutional amendments and require only a simple majority. This is a absolutely right option because it talks about simple majority, and it also states that laws passed under 2 and 3 are not constitutional amendment. D says 2 and 3 exclusively deal deal with the amendment of the constitution, again a wrong option. Let's see the last question of this passage. Fifth question says the distinction between Union of India and Territory of India as defined in the Indian constitution primarily highlights which aspect of the Indian federalism. Let's see the options. A says the equal status of state and union territories in the union. This is a wrong option because the Indian federalism is not about the equal status but different responsibilities and powers to the state and union. B says differentiation between political and administrative division of India. This is a right option because when we talk about the Union of India, that is state sharing power with the center, and Territory of India, that is all states inside the Territory of India, means the political and administrative division of India are different, differentiation between it. So this is a right option. C says supremacy of union government over states and territories. This is again a wrong option. There is no such supremacy. There is a federal structure which is being followed. D says inclusion of potential future acquisitions in the Indian territory. This is a inclusion can be seen, but the primary distinction is that how the states and center act with each other. So this is also a wrong option. I hope the passage was understandable. All the best.